Section R, brokerage firm services and disclaimers. R1 is scope of service and disclaimer by brokerage firms. Brokerage firms assisting in this transaction, including their owners, licensees, salespersons, agents, employees, strongly recommend that buyer and seller each consult their own attorney, estate planner, accountant, appraiser, architect, pest control expert, home inspector, insurance advisor, contractor, land surveyor, electrical engineer, civil engineer, structural engineer, soils engineer, land use professional, zoning expert, environmental expert, designer, title insurer, other professionals and or subject matter experts should they have any questions within those fields about this transaction. Buyer and seller understand that the brokerage firm have not made any representation or warranties and have not rendered any opinions about A, the legal or tax consequences of this transaction, B, the legality, validity, correctness, status, existence, or lack of any building permits which may have been required for the property. C, the land area of the property, the location of the boundaries, or the size of the improvements of the property. Or D, any of the matters set forth in paragraph I-6, general disclosures. And then in bold, buyer and seller understand and acknowledge that the parties are not relying upon brokerage firms for any of the foregoing services or advice. R2 continues, rental property. Buyer understands that seller and brokerage firms are not offering to sell or selling the property together with an existing or future rental pool or other rental arrangement. Seller and the brokerage firms make no representation or guarantees about future rents. Buyer understands that should buyer rent the property after closing, buyer is assuming all risks relative to all of the foregoing. This sale includes real property only, and the intent is not to convey a security or investment security as defined by the U.S. Securities and Exchange Commissions or other government agency. R3 is future resale value. Seller and brokerage firms make no representation or guarantees about future resale values. R4, obligations. Brokerage firms shall not be held liable to either buyer or seller for the failure of either buyer or seller to perform their obligations under this contract. R5 is permission. The parties grant brokerage firm permission to supply data to multiple listing service regarding the sales price, terms, and listing status of the transaction for use by other brokers and real estate professionals in making market studies, providing service to the public, and advising their clients. R6, disclosure of real estate licensing status. Hawaii law provides that the licensee shall not acquire, rent, lease, sell, or exchange an interest in or buy, rent, lease, sell, or exchange for oneself any member of the licensee's immediate family or brokerage firm or the entity in which the licensee has ownership interest, property listed by the licensee's brokerage firm, or listed with any other brokerage firm or licensee without making the true position known in writing. And then it has in there, you would put X or NA, and then the disclosure of the licensee. So if you are a licensee buying or selling your own property, in this case being buying your own property, you would just put buyer is a licensed real estate agent in the state of Hawaii.